I don't know.
What is your name and badge number?
It's 259 Garner.
Good.
So I'm recording too.
Go work.
Don't tell me what to do.
Don't tell me what to do.
Back up.
I'm backed
So
up.
you got your hand in your pocket.
Yeah, so?
Take your hand out of your pocket.
There's no login set.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Our case today comes to us from the YouTube channel Donald McKenrick, which I assume is just someone's name, and it depicts an arrest of who I assume to be Mr. McKenrick in Great Falls, Montana, for apparently an obstructing charge after he approached officers and filmed them from a public sidewalk. Now, I haven't made any substantial edits to the video, but I encourage you to please head over to Mr. McKenrick's channel, show him support for both filming the police and sharing his experience. With that, let's check out part of the video and then we'll come back and talk about the law.
I'll mind that you record, sir, but you need to back up, okay?
Where's the crime scene tape?
No crime
I don't need to
scene
back
tape, but
up. There's no
this-
laws saying that I can't be close to you guys. None. And I'm
is.
far enough
Yep,
away
but
from that
you're
squad
hindering-
car.
You're hindering our ability because, nope, don't.
Hindering what
listen,
ability?
Because we can't work while we have to pay attention to you.
Don't pay
I
attention
know
to
you-
me.
I don't
I'm
know
not.
you
I'm
from
not
Adam.
talking to you guys
I don't
one
know
bit.
you from Adam,
I don't
so
give a
just-
shit. I'm on public sidewalk.
Okay, so you can tell that Mr. McKenrick is approaching an area where 3 police cruisers are positioned at various locations on the city street. None of the cruisers have the lights on, at least not visible from the direction from which Mr. McKenrick is coming. There's no defined scene. There's certainly no crime scene tape. So Mr. McKenrick approaches a vehicle that is marked as a sergeant's cruiser, and there's a female officer standing outside of it with her back to Mr. McKenrick. The female officer looks in his direction briefly and almost immediately turns away from him and begins to focus her attention to her left and sort of seems to be conversing with the sergeant that's still seated in the car while having divided attention to the left. Around 30 seconds after McKenrick's initial approach, you can see in the distance that an officer steps out of the second vehicle back and begins to approach Mr. McKenrick. That vehicle is probably, 3 car lengths away or so. The average car length of a SUV is 18 to 20 feet, so probably 50 to 60 feet away from the female officer who's standing there. This officer immediately says the thing we all know is not true, which is that he doesn't mind recording. Now, how do we know that that's not the truth? Well, there's like a but rule in linguistics. Everyone knows that when there's the word but in the middle of a sentence, and the first part of the sentence is some sort of a disclaimer, anything that follows the but will be contradictory to the disclaimer. Let me give you an example. If I say, I'm not a racist, but, then there's a 100% chance that whatever I say next will in fact be something that could be taken as racist. Otherwise, there's no reason to make the disclaimer, right? I mean, it's the same thing as saying, the thing I'm getting ready to do will 100% lead you to believe a certain thing about me or about what I'm trying to say. But I'm going to tell you that's not the case because I need to gaslight you into questioning what you know about the way the world works. And if we follow that logical template, it becomes pretty obvious what's going on here. He has a problem with recording. So Mr. McKenrick does exactly what he should do, and he asks the sergeant to define the scene. What area are you trying to protect? Where is your police activity? Where's your crime scene tape? To which the officer responds with nonsense. Now, McKenrick ends up asking for his name and he says it's Sergeant Garner. I would have assumed it was Barney Fife, but apparently it's Sergeant Garner. Now, Sergeant Garner, of course, does not want to define a scene because his concern is not their job. It's the fact that McKenrick's there and he doesn't want him to be there. He doesn't offer to explain what's being done or how Mr. McKenrick's presence is obstructive in any way. He just wants to control a person on a public sidewalk. So McKenrick pushes back. Now, I want you guys to watch what happens next. We're already off on the wrong foot because the cop, as we can see, approaches this situation all wrong. But there is a turning point coming, and it's obvious when it happens. So check it out.
I am not interfering with your guys' business. Stay out of mine.
You're obstructed.
I am not. I haven't said one fucking word to you guys.
Okay, I slowed it down. I'm going to repeat it again so you guys can see it. Watch Garner's facial expression change after he interprets McKenrick saying the F word as cursing at him. You can tell that everything in his body becomes offended by this word or by this phraseology that comes out of McKenrick's mouth. Now again, what is actually happening here? I mean, nothing. He's accusing McKenrick of obstructing nothing. So let's look at Montana law and see what an actual obstruction charge looks like. Montana Code 457302, obstructing peace officer or other public servant. Number 1, a person commits the offense of obstructing a peace officer or public servant if the person knowingly obstructs, impairs, or hinders the enforcement of the criminal law, the preservation of the peace, or the performance of a governmental function, including service of process. Okay, so I guess the first question we need to ask is, what are they trying to do that can't be done because Mr. McKenrick is on a public sidewalk filming them? Also, take note of what the intent standard is, or what the law refers to as mens rea. It is a knowingly standard. Now, I was able to research and find out that there's a very specific definition for knowingly under Montana case law, and that'll help clear things up. So the Montana Supreme Court has established that whenever a person is tried for an obstructing charge, the jury must receive the instructions that include a definition of what knowingly means under Montana law. And it means that a person has to have an awareness that it is highly probable that his conduct will obstruct, impair, or hinder the officer's performance of their governmental function. So that clears it up a little bit, but we can just basically follow common sense and understand that in order for Mr. McKenrick to obstruct, he would need to know that the officer is trying to perform a governmental function, and then he would have to be intentionally trying to keep him from doing it or hinder him from doing it, or at least do something that would slow it down or have some impact on the governmental function itself. Now let's watch some more of the video and see if maybe we missed something and see if this gets cleared up at all.
Not one.
We gotta pay attention to them.
Pay attention to them, not me.
Back up.
I'm backing up 10 feet. That's it. I ain't backing up no further.
I just asked you to back up so
I
these
did.
guys can work.
I did back up. I ain't backing up no further.
Okay. I don't know what jollies you get out of recording.
You know what?
But the fact is,
Don't pay attention to me. Pay attention to your fucking
I
job.
don't know you.
I don't care.
I don't.
What
know
is your
your
name and badge number?
It's 259 Garner.
Good.
So I'm recording too.
Go
but
work.
Don't tell me what to do.
Don't tell me what to
Then
do.
Back up.
I'm backed
So
up.
you got your hand in your pocket.
Yeah, so?
Take your hand out of your pocket.
There's no law against that.
Take your hand out of your pocket.
No law
Put your
against
hand
that.
behind your back. You're under arrest.
For what?
Obstructing. Take your hand up.
Okay, so finally, for the first time, we get some indication from Garner that there is an actual area that they're dealing with. They're dealing with some issue at the house, which would be to Mr. McKenrick's left and the female officer's left when she had her back turned. So Garner says, we got to watch them. We can't pay attention to you. But again, he didn't do anything that would require them to pay attention to him. He didn't get super close or anything like that. He's a good, 10, 12 feet away, even while he's filming. That also would kind of explain why the female officer was dividing her attention and keeping her focus to the left towards the house and not looking at Mr. McKenrick as he approached her. So clearly something's going on at that house. Now, sharing what I know about police calls, I can try to help you guys understand the dynamic here. This is what the scene tells me. We don't see emergency lights on. That means that it is not a traffic stop. It's not like somebody pulled into the driveway because they wouldn't have turned off their lights. And it's not an emergency. So they didn't run their code or anything like that. Or at least if they did, everybody's fairly calm considering the adrenaline that happens with something like that. As cars pass, they have their headlights on. This video was taken in February, so it's either dusk or very early morning, though it's not clear which one. Now, Garner just pointed to a house, and so what's more than likely going on is that there's a disturbance call of some sort at that house. That would be the only reason to have like multiple officers, but no lights on, and a need to keep a continuous eye on the house. But here's where it gets tough for the cops to make out a case. There are 3 police cruisers on scene that I can count. I'm going to overlay the video here. You'll notice that as Mr. McKenrick's video captures the sergeant's vehicle, the one that's in the very front, you can see a police vest hanging on the front passenger seat. That's a pretty good indication that he's solo. Otherwise, his gear wouldn't be on the front passenger seat where someone else would be sitting. Garner is clearly a sergeant because you can see the stripes on his arm, and he gets out of the second cruiser back. More than likely, he's also solo because generally sergeants on patrol don't roll with trainees or partners. That leads me to believe that the cruiser furthest away probably belongs to the female officer. Now, it is possible that she has a partner inside the house where the call is, but it's not very likely because if you're there to back someone up on a disturbance, you wouldn't be outside while your partner's inside most of the time, unless you were separating the two parties. And if she'd had a trainee, she would never leave a trainee inside to deal with a disturbance alone. That creates like a bilateral liability situation. You get the trainee hurt because you're not properly supervising them, or you get the public hurt because she doesn't know what she's doing. So it's liability flowing from both directions. The female is not a trainee herself because she clearly has corporal stripes on her uniform. So whatever's happening is so non-emergent that none of the officers on the scene are directly supervising anyone in the house. There's no crime scene tape, there's no emergency lights, nothing. Now we do have some additional footage that apparently McKenrick's buddy took as he was being arrested. So we'll go ahead and look at that. It shows a completely different angle, and it shows definitively that he was nowhere close to any distinguishable police function. Let's watch.
Don't tell me what to do. Get your then back up. See, you got your hand in your pocket. Yes. No. Take your hand out of your pocket. Take your hand out of your pocket. Okay. Long chair behind your back. You're under arrest. That's right.
Now, it is possible that they have one party to this disturbance may be detained or sequestered in one of the cruisers, but that wouldn't really explain why they need to monitor the house. And more importantly, there's not much of anything Mr. McKenrick could be doing to disrupt their investigation or the job they're doing. The videos show as much. The female paid him no mind and kept her attention on the house with the exception of like 3 seconds when he first walked up. So clearly he wasn't keeping her from doing whatever she was doing when he walked up. In the area where Mr. McKenrick is, no one is writing a report, interviewing anyone. He doesn't speak to the police at all, as he indicated in his protest. He didn't say a word to these guys. He didn't do anything except walk up and film. He doesn't ask questions. He does nothing except record. And this is really kind of a perfect audit because all that remains here as an offense is contempt of cop. Even when Garner demands that he back up, he backed up an additional 10 feet. And that's important because remember when I froze the camera on Garner's facial expression the first time? There was actually one time before that where you could tell that he was visibly offended. So let's go back and look at that again. When we go back to the first time that he curses, he says, "I don't give a shit. I'm on a public sidewalk." And you can actually visibly see that Garner's face changes.
From Adam.
I don't give a shit. I'm on public sidewalk.
And then when McKenrick says the F word, Garner is frozen and then starts walking towards him. So Mr. McKenrick says he's backing up 10 feet and Garner kind of throws his hand up and he gives an indication, well, you know, he's satisfied with that. He's not going to do anything else. But then McKenrick says something that bothers him again. He says, "I've backed up 10 feet and I'm not backing up anymore." And you can see Sergeant Garner's face change again. And then it goes right back into this pissing battle. And it becomes painfully obvious that this is nothing more than Garner being told he's not going to control Mr. McKenrick. And Garner subsequently taken that information as a challenge to do just that. And he ultimately makes an unlawful arrest as a result. I say unlawful because, again, of what the case law definition of knowingly is and what the obstruction statute says. The cases in Montana have made it a requirement that knowingly standard be explained to the jury during trials, and the Montana Supreme Court has reversed and remanded multiple cases for a new trial when the jury hasn't been given the information of what it actually means to have a knowingly state of mind. So again, they have to have an awareness that it's highly probable that their conduct will obstruct, impair, or hinder the officer's performance of the government function. So I ask you, from the less than 3 minutes that Mr. McKenrick was on this scene, did he even learn what could possibly be happening that an officer's government function is? Even after speculating broadly, based on the scene, have we even learned what their government function was? What in Mr. McKenrick's conduct could possibly use to support the argument that he obstructed their ability to do their job? You guys tell me in the comments. In closing, this is how you lose your house because you can't control your ego. If any federal circuit will strip qualified immunity from a cop, it is reliably the Ninth Circuit. And that is where Montana is located. What in the way of the conduct of the police officer is defensible here from a qualified immunity standpoint? What is the arguable probable cause here? To survive an attack on qualified immunity, the officer would have to have arguable probable cause. So what law enforcement function could even be identified from this video that could be obstructed or hindered? Wouldn't the police have to show that they are making an effort to do something that Mr. McKenrick hindered them from doing? I can't see a single thing that they were actually doing other than one of them looking at a house. And that one continued to look at the house. So there wasn't anything that they were doing that they didn't continue to do after he walked up and was filming. We know that the Ninth Circuit has clearly established the right to film the police. We just went through this with the Chile de Castro case. Not on an appellate level and not on a federal level, but in the same federal circuit. Mr. McKenrick's conduct was not even as obstructive as Chile's, and we don't think Chile's was obstructive. So how do they make this case work? They can't. This is nothing more than First Amendment retaliation, either for the recording or the speech or both. This is a loser of a case for the state and a slam dunk civil rights lawsuit, albeit without very much in damages. But my biggest hope is that there is a civil rights lawyer in Montana that's willing to take this case just for the purposes of principle, or willing to stand on this guy's right to record. I mean, he is a sympathetic plaintiff. He did absolutely nothing offensive. He was only defending himself when the officer started accusing him of doing something he wasn't doing. He didn't fight back. He didn't do any of the things that would leave a jury not to like him. I mean, he really didn't do anything wrong at all. He just walked up and tried to film and got arrested for it. Now, they did cut him a citation and cut him loose, but that's not the point. It's still an arrest. It'll still be on his record as an arrest. All of that will still be in place, and those are damages. Anyway, that's all for this one, guys. I hope you got something out of it. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.